Hello and welcome back to part two of a fistful of legal issues. This is Roger Royce, host of the 10,000 Startups podcast, where every week we try to bring you original content on legal issues of interest to startups. There is so much going on right now, so many changes, so much activity, things change almost daily. The last couple of podcasts, we've been just trying to keep up in developments in the law that might be of interest to you. And I'm going to continue with that this week rather than doing a deep dive in any specific area. So, a handful of topics. The first one, you may recall we did a podcast recently on the FDA, Food and Drug Administration's final rule, which was issued about a year ago on laboratory developed tests. So, if you're in the space, you know exactly what I'm talking about. The FDA is regulating all laboratory developed tests, LDT, which is a term of art, as medical devices, bringing them within their regulation. Well, there's a court in Texas, District Court in Eastern District of Texas, just recently has ruled in favor of a plaintiff on a summary judgment motion. That was American Clinical Laboratory Association. And they set the FDA back. It's a pretty significant victory for the clinical laboratory industry because LDTs are not medical devices under that test. We all saw this coming. If you tuned in to earlier podcast, you heard me talk about the Supreme Court decision in Loper Bright, and we might have concluded that it didn't really matter all that much with the change in the administration, but now we got a court decision that came down on the side of industry. Now, this is a complex case with a lot of defined terms, and it's fairly limited, and we have to be careful because these LDTs and related products are subject to other regulations, both federally as well as state. But this goes a long ways towards giving some relief to the startups that are developing LDTs and may have one less hurdle, one less piece of regulatory capture, keeping them out of the market. Moving right along, kind of an interesting case, at least to me, on worker misclassification. We've done podcasts on misclassification. Here in California, you have to pass a, a three-part test in order to classify a worker as an independent contractor, not an employee. If you get that wrong, that could be big liability for the company. Tax withholding, penalties, um, class action, overtime, meal breaks, attorney's fees, waiting time, and even potentially personal liability. It's a big deal. And as you probably know, here in California, it's really difficult to classify a worker as an independent contractor. Not impossible, but really difficult in most industries. But the statute that does set these high standards for classifications have numerous carve-outs, quite a few exceptions, depending. And if you have a good enough lobby in your industry, you probably have one of those exceptions. Well, the city of San Francisco is bringing its own lawsuit against a gig company. It's a delivery and moving services platform called GoShare, and it does exactly what you would expect: delivery and moving services, mostly last mile. And the city of San Francisco has sued that company. And by the way, they sued everybody else in the space too, it feels like. Lyft, Uber, DoorDash, Instacart, GigSmart, WorkWhile, and Quick. And some of them have resulted in settlements. Some of the litigation continues, Lyft and Uber. But it's interesting to me that this is a San Francisco city attorney filing this suit, as if there weren't enough reasons to avoid San Francisco. Here's one more for you. Um, and apparently they just love getting their name in a paper because they're going after these companies, even though clearly everybody does not want that particular law enforced. The people who do the work, they don't want it. The people who actually contract for the work, I mean, we've seen that in our referendum process. These are enormously unpopular laws, but nevertheless, they're on the books, and I guess it gives board city attorney something to do. So that lawsuit is going forward. We're going to keep an eye on that. and see how it goes, because you might see similar lawsuits around the state and even in some other cities. Now, to be fair, the position of the city of San Francisco is that these people need basic labor protection that employees get, that gig workers don't get: minimum wage, overtime pay, mandatory breaks, paid family leave, expense reimbursement, paid sick leave, unemployment insurance, disability, and workers' comp. So they're going to try to protect those workers. As you can imagine, that definitely can increase the amount that it costs to hire somebody like that. And those costs are typically passed along to the consumer. So that's why these are unpopular laws. But we'll see how it goes. So that is the case against the company GoShare in San Francisco. Moving along to crypto, I don't really report that much on crypto anymore. I stopped a few years ago when the SEC drove that entire industry outside the United States. Didn't see much point. But now it's back. As you probably know, the SEC is going to take a kinder, gentler approach to crypto. They've already classified tokens as non-securities. They've resolved they're going to regulate and not just simply enforce and let you guess what's legal and what's not legal. And now the U.S. Department of Justice has now weighed in a memo they issued this week that says effective immediately, they are disbanding their National Cryptocurrency Enforcement Unit, which was dedicated to crypto-related investigations. So that's a big deal. And what they say is that, look, we're not a digital asset regulator, and we're not going to target virtual currency exchanges, mixing and tumbling services, offline wallets for the acts of the users or for unwittingly violating regulations. So instead, they're going to focus on individuals who victimize digital asset investors or use digital assets in furtherance of criminal offenses. So that's a victory for the crypto industry, one less regulator to worry about as long as you're not engaged in some sort of criminal activity. Continuing with federal developments, this one goes the other way. Department of Justice, under an executive order, the Department of Justice National Security Division just implemented a data security program. And the idea is to address national security risk associated with foreign access to sensitive U.S. data. Now, specifically, what the executive order says is that this data security program, is designed to prevent China, Russia, Iran, and other foreign adversaries from using commercial activities to access and exploit American sensitive personal data to commit espionage, conduct surveillance, and counterintelligence activities, or otherwise undermine national security. So it's a national security directive. It's not a privacy regulation. It's not designed to protect individual privacy rights. It's more like a U.S. sanction or an export control regime. And it became effective here in April, and there are other compliance requirements taking place in July. So if you're the kind of company that collects this sort of data, you're now subject to restrictions that we used to only think about for things like the defense sector or highly sensitive government contracts. And there are significant civil and criminal penalties and sanctions that apply. So check in on this, the data security program under the executive order, if you're collecting tons of bulk sensitive personal data of U.S. persons or government related data. So I want to weigh in some tax stuff. I know as a startup company, you probably don't even think about tax issues very much because to pay taxes, you got to have income. And how many startups do you know actually have net income? If they do, they're probably doing it wrong. However, I think this is something we should take a look at because we're all concerned about after-tax results. So tax release from House Ways and Means in this month in April. The House, keep in mind, as you know, revenue measures originate in the House. And the House adopted a budget resolution. That's kind of how all the tax legislation gets passed these days, is through budget reconciliation. Anyway, they adopted a budget resolution approved by the Senate that would allow the permanent extension of the expiring provisions of the Tax Cuts and Jobs Act. and provide an additional $1.5 trillion of tax cuts, as President Trump promised in his campaign. It uses a scoring tactic, which I'm not going to get into here, to justify the extension or the cuts. The big thing to notice is that this latest budget resolution approved by the Senate is well on its way to making permanent quite a bit of the Tax Cuts and Jobs Act. Just a couple weeks ago, I did a podcast on what the tax proposals are. Here in Silicon Valley, the big one that we're all wondering about, and which went away on us, is how R&D expenses are treated, whether they're capitalized or expensed. And a lot of companies have been having to capitalize these R&D expenses for quite a while. So we'll have to wait and see how we come out on that. But on most of the other stuff, it's going to be more business as usual because the tax cuts are going to be extended. Now, the final thing I want to mention here, we are going to do a PAGA podcast one of these days soon. PAGA is Private Attorney General Act. I think it is so important because it is one of those weird things about California law that people don't believe until they get stung by it. And the Private Attorney General's Act is kind of what you'd expect. It allows, it's similar but way different from class action, and it allows individuals with claims to bring their claims on behalf of other parties that are similarly situated, almost always in the case of labor code lawsuits. And there's been a lot of activity in this space, people trying to get around this, trying to put these things into arbitration so they don't end up challenges that like a person may have settled their claim, but then will bring a claim on behalf of somebody else. So the California Supreme Court recently decided an issue, and it's what they call headless PAGA claims, which is a strategy where a plaintiff brings a claim under a PAGA Act by suing only on behalf of the coworkers and not themselves. So this tactic, we'll call it, or this strategy, the panel held, is that the plaintiffs in that case, they cannot avoid contractual arbitration if they do that. So there you go. That was the way people were trying to stay out of arbitration. All I'll say about that now is that the employers like this. It's a blow to a litigation tactic. And, stay tuned. The PAGA Claims Act was recently amended here in California. It made some changes, cleaned up some things, tightened some things. But we are going to do an entire episode on Private Attorney General's Act and how you can avoid, if you're a startup employer, from getting stung by that. Okay, that's it for this episode. Hope you enjoyed it. I'm Roger Royce, host of the 10,000 Startups podcast. We'll be back next week. We're going to cover a couple of interesting topics coming up. You'll be sure to want to tune in. Thanks, and see you next time.